Well, welcome to our micro-learning podcast on the FASB's project to simplifying the balance sheet classification of debt. As part of its simplification initiative, the FASB issued a proposed accounting standards update in January 2017, which would change how companies classify debt as current or non-current on a classified balance sheet. Before we get into the details, it is worthwhile to note that the proposal would likely cause more debt arrangements to be classified as current liabilities than under existing U.S. GAAP. Can you provide some insight into why this is viewed as a simplification project, the scope of the proposal, and what it would require?
Sure. Stakeholders told the board that the current guidance on determining whether debt should be classified as current or non-current is overly complex because it includes guidance on various narrow-scope, fact-specific transactions. In fairness, this guidance has been developed over the years in response to specific questions that have been raised by constituents. The scope of this project would apply to all debt arrangements, including convertible debt instruments and liability, classified, mandatorily redeemable financial instruments. The proposal will replace the existing guidance with a principle-based approach. Under the proposal, the general principle will require a company to classify its debt as non-current if either of the following two items are met. First, the liability is contractually due to be settled more than 1 year, or operating cycle if longer, after the balance sheet date. For example, a borrower that has a loan that is due in 5 years would classify it as non-current. Second, a company has the contractual right as of the balance sheet date to defer settlement of the liability for at least 1 year, or operating cycle if longer, after the balance sheet date. For example, a company has drawn down on a revolving credit agreement that has stated maturities of 90 days, but is continuously renewable at the borrower's option for 3 years. Since the borrower may defer settlement beyond 1 year, it would be classified as non-current. Not surprisingly, perhaps the board did provide an exception to the general principle. A company that has debt that is callable at the balance sheet debt because of a covenant violation can still classify that debt as non-current if it obtains a debt covenant waiver after the balance sheet date, but before financial statements are issued, or available to be issued for non-public entities. Can you provide additional context as to why the board decided to provide this exception?
Yes. An exception provided for debt classification when a lender has the right to demand payment because a debt covenant violation exists as of the balance sheet date. A company would classify this debt as non-current if it meets the following. The debt would have been classified as non-current if covenant violation had not occurred. The lender waives its right to demand payment of the debt for a period greater than 1 year or operating cycle, if longer, from the balance sheet date. The borrower obtains the waiver before it issues its financial statements or before the financial statements are available to be issued. It is not probable that the borrower will violate any other covenants that are not covered by the waiver within the next 12 months or operating cycle, if longer, from the balance sheet date, and the waiver does not result in a modification that is accounted for as either an extinguishment of debt or a troubled debt restructuring. A company would present debt that is classified as non-current as a result of the waiver on a separate line item on the face of the classified balance sheet. The board decided that in many cases it is not practical for companies to obtain the waiver from the lender before the balance sheet date for a variety of reasons, including the fact that the entity and lender may not know that there is a covenant violation until after the period ends and the entity begins to prepare its financial statements. As a consequence, the board concluded that this exception to the classification principles, supplemented with the additional presentation and disclosure requirements, would provide useful information to financial statement users. One example where there is expected to be a change in classification as a result of the proposal is for debt that contains subjective acceleration clauses or material adverse change clauses. Current U.S. GAAP requires entities to consider the likelihood of acceleration when determining classification. The proposal would remove that probability assessment, and a subjective acceleration clause would impact classification only when it is triggered. So far, we have discussed presentation requirements. Does the proposal impact any disclosure requirements?
Yes, the proposal will require a company to disclose information about events of default. Events of default include loan covenant breaches and when subjective acceleration clauses are triggered. A company will be required to disclose the following: a reason for the default, the amount of the obligation subject to the default, the terms of the waiver, a description of the actions that the borrower has taken or will take to remedy the default. Finally, in terms of implementation, once issued as a final ASU, the standard would be applied prospectively for annual and interim periods beginning after the effective date. The board will determine the effective date after it evaluates stakeholder feedback.